Iwi huri huri nei, nau mai haere mai kai tēnei hui, tēnā koutou katoa. Kia ora everybody, my name is Chris Gallavin. It's great to see you all here tonight. I thought I might have been speaking to myself with the weather as it is tonight, but I applaud you and congratulate you for braving the weather and coming out and having listen to what I hope is going to be a relatively interesting talk and some things that might, some themes and topics that might spark some debate and interest and some questions and even some cynicism perhaps and disagreement between us. Matters of justice are as common as there are people as to the attitudes and approaches to justice, and it's certainly not a case that we could actually come up with one universal system that would cover everybody, or perhaps not. Before I start, and I'll do a bit of an introduction about myself and go through what I'm going to talk to you tonight, I need to go through the emergency procedures in the case of emergency. We've got an exit up there to my left, and that just brings you down to the main foyer where you came through, and of course the door that most of you came through. If there is an emergency, I don't know, an earthquake for example, then the perceived wisdom is now that we stay still, that we remain calm. If you can cover and hold and get some under the tables, then do so. But if you can't, stay where you are. Don't move while the shaking is continuing. When the shaking stops, we move in an orderly and calm manner out of the building to the Clyde Road car park, which is the large car park that probably most of you have parked in to the east of this building, and that's where we will congregate. So come in. Chris Gallavin is my name. I am an associate professor here at the law school at Canterbury University. For my sins, come in, have a seat. For my sins, I am also the head of school and the dean of the faculty of law. It's actually a great honour to hold those two positions. It's particularly a fantastic faculty with a great history and a real vibrancy to it post-earthquake. And as with everybody in Christchurch, we've gone through the ringer. We've done a lot of introspective navel gazing. We've come up with a plan that we think is pretty exciting, and I'll weave some of those things into the presentation that I'll give you tonight. But it's a great place to work, and I'm very passionate about what I do and the colleagues that I have the privilege of rubbing shoulders with, and there's a couple here tonight, so they can report back to the rest of the team that I was very, very nice about them. So tonight we're going to talk about, the what if theme for tonight is what if we had free access to the courts? And when asked to give a What If Wednesday talk, and I was thinking about what topics I could talk about, I really sort of relished the opportunity because, and this might sound silly for an academic to say this, but I get very little opportunity to really actually stand back from my subject matter and have a look at the panacea, the whole topic as a whole, and start making and drawing conclusions about where as a society and as a community and as the topic as a whole might be developing. My areas of expertise are the law of evidence, and I've written New Zealand's book, or one of New Zealand's books, on the law of evidence. And the law of evidence is a highly regulated thing in a common law world, and it governs principally the admission or admissibility of evidence or the exclusion of evidence. The other areas of my expertise are culpable homicide, murder and manslaughter in New Zealand, and comparatively in other jurisdictions. A lot of my publications don't merely look at New Zealand. We're not the only ones who are grappling with these problems, but actually compares the development, history and the future of our law in relation to other jurisdictions. And also the law of consent. So the law of consent relates to, often manifests itself in all the nasty, horrible crimes of sexual offending. Consent is a pivotal issue, but also in the extremes of behaviour that people get themselves into about what you can and can't consent to, and raises some really interesting philosophical questions about who we are as autonomous individuals. So I really enjoy those areas. I did my PhD in international criminal law. The title was Prosecutorial Discretion in the International Criminal Court, the ICC, which is based in The Hague and Den Haag in Holland. Probably guaranteed to send you to sleep in the first page. A work of genius, I think, of course, but I would say that. I must admit it probably is a little dry, but I love doing it, and reached some conclusions that I think, at least in the international criminal law area, are interesting. And so did my examiners, thankfully. So I came back to New Zealand, lived overseas for about 5 years, came back to New Zealand in 2005 and came back to Canterbury University where I'd done my undergraduate degree and worked my way up through to the position that I find myself in today. So that's a little bit about me. What are we going to talk about? It's a structure. I want to talk for 40, 45 minutes and then open it up for some questions and some discussion, even some debate. You know, your opinions and attitudes and ideas about accessing justice, I'd really like to hear them. Going to start off with a bit of an introduction, look at the thesis and themes that I want to focus on today, and some of the key concepts that you see bandied around in the context of access to justice, and actually we'll spend a little time about what they actually mean and what's their relevance in the context of what we're talking about. We'll have a look at the extent of the problem of access to justice. I keep on saying access to justice, and in a moment I'll explain and perhaps give an overview of what, for me, free access to the courts actually means and what it looks like. And I think it revolves around access to justice. So the extent of the problem of that we find ourselves in New Zealand, let alone Christchurch, and then going on to access to justice itself and having a look at the main drivers of those things that I think that are contributing to people's inability to be able to seek the help and get the help and assistance they need to resolve their disputes and problems. And then we'll have a look at some possible solutions. And there is no one particular solution that I think is going to solve all our problems of access to justice. There are a number of different things that we could do better, and each of these, if there was a report card for these, could do better, would probably be a common theme. So, what if we all had free access to the courts? There's a couple of ways we could look at that. When I first thought about it, I thought, well, in the narrow, that's quite an easy answer to a question to answer. You take away court fees. You take away costs awards from judges who are penalising or effectively punishing a party for bringing a case if they lose, which of course is a significant and serious impediment for you taking a dispute that you might genuinely believe that you have. Yes, of course, you've got those examples where you've got the vexatious litigant or those people who have acted in bad faith and have brought other people and tied up the system, brought other people into the court process and tied up the system itself. Yes, you do have those, but for the common run-of-the-mill person, their day in court is an important, in a sense, constitutional right. We'll talk about that in some detail as well. And so you would say, let's get rid of the filing fees. Let's get rid of, they don't really cover the costs associated with going through the court process anyway. So that we could get rid of those. We could get rid of the cost orders. And we could probably, you know, if we were going to get on the public bandwagon, get rid of those lawyers. And that might be three things that you could do relatively easily. Perhaps the last one, the lawyers might kick up a bit of a stink, but there's probably not a great deal of sympathy around the community for the task of lawyers. I hope to change that somewhat tonight, by the way. But those are things that you could probably do straight off the top of the head that would ease the congestion and ease the problem of access to justice. But that would be looking at it in the narrow. Because what I really think about, what if we had free access to the courts? When you start thinking about the justice system, especially the criminal justice system, but not limited to criminal justice, so is the civil and family systems, dispute resolution, all sorts of alternative dispute resolution, or just dispute resolution. It's no longer in vogue to call it alternative dispute resolution, as if it is some sort of, playing second fiddle to our normal traditional processes. But, you know, there's much, much more to it. You know, we're looking actually the fabric of society as to why people come up, have disputes, have conflict with one another, and what they might actually do to engage themselves, to put themselves in the position to have those effectively dealt with. And the court might actually be the very last part of the process of having those issues dealt with. So if we're going to talk about access to courts, and particularly if we're going to look at it through the lens of access to justice, we're really missing, it's just the tip of the iceberg, we're really missing the main point. And so the broader issue, I think, of what if we all had free access to the courts, that I think is more interesting, is that what happens if we had free or ready or accessible access to dispute resolution systems that met our purposes, whether they're in the criminal sphere, whether they be in the civil sphere. insurance, EQC, for example. What happens if you actually had mechanisms in place, plural, in order to be able to readily affect and give effect to the resolution of your problem. So that's how I'm interpreting what happened. What if we had free access to the courts, rather more broadly. So let's have a look at probably the main thesis. My main thesis is that perhaps we're standing at a time where we have the opportunity to rethink how we deliver justice. The opportunity to rethink. I could have stood up here and said that we have an imperative to change access to justice, and there's plenty of evidence to suggest that we have such an imperative. But I thought it would be much more positive to come from the angle that we have an opportunity to. And I think we in Christchurch have the greatest opportunity that any group of citizens in New Zealand has ever faced to change everything. Now, I'm passionate about Christchurch. I think we've got much more to teach the rest of the country than the rest of the country has to teach us. Yes, we've got problems. Yes, we've got frustrations. Yes, in 10 years' time, they keep on telling us it's going to be a great city. I think it's a great city now. And I think that especially for young people who I'm standing often in front of course, you're all young people here tonight as well, but the young people that I stand in front of, I say to them, you'd have to have rocks in your head not to want to be a part of what's going on down here. It's bigger than Ben-Hur. They have no idea who Ben-Hur is, so they don't know what I'm talking about. I just said that means it's big, right? It's big, and yes, it's frustrating, yes, it's gritty, but this is the single most significant opportunity that New Zealanders have ever faced in the history of New Zealand, and I'll stand by that and argue till I'm blue in the face anybody wants to challenge that. $40 billion is an incredible injection into a community, and it's not merely about bricks and mortar. It's about renegotiating the foundational building blocks of who we are as a community, and where else do you ever get that opportunity, ladies and gentlemen? Hopefully we'll never have, touching wood, that's probably veneer, there's probably no wood around me. Hopefully we'll never have the opportunity or the misfortune of being faced again with the circumstances that gave rise to this opportunity, but now we are here. It's incredible. It's absolutely incredible. So I always say to the young people, you've got to find your passion. You're needed down here. Whether you want to do fine arts or performing arts, or you want to be an engineer, you're needed down here because the vitality of this community needs young people. It's a young person city, and I always say they need to take it by force if they need to, if they have to. They never pick up on that, probably quite thankfully so. They say, well, the Dean of Law told me to be protesting or to be arrested, then I might get myself in trouble. We have a great opportunity to rethink how we deliver justice. What I think are some of the drivers as to why I say that. One is inequality. There's a report come out yesterday, and I've got it written down because I can't remember the name of the report. It was only released yesterday. It's an update report, and it is the updated 2014 Household Incomes Report, which, if you're to believe its pages, says that inequality has stayed relatively stagnant since the early 1990s. Well, that might be so, but I don't necessarily think that means we're in a good place. We're about middle of the road with the OECD rankings. It says that in the last couple of years for 2012 and 13, that in real terms, household income has increased by 4%. They mean real terms because that's over and above the rate of inflation. But they do actually say, if you read the fine print, that really is just replacing the 4% that was wiped off the books with the global financial crunch from the 2009 to 2011 time that the catchment that they last did that report. They also say that it's only an income assessment. There's all sorts of different ways that you can measure inequality. Income of one of those, and this is the household income report. It notes that, it's not a wealth report, and it makes it very clear that it doesn't get into the notion of wealth, which is more expansive and covers savings where income is not cognizant or positively disavows itself of those indicia. So as far as wealth is concerned, 10% of the most wealthy in New Zealand hold 50% of all household wealth. 10% of the most wealthy hold 50% of all household wealth in New Zealand. As far as income is concerned, it's about half that. So 10% of the highest household income quarter or percentage hold 25% of all wealth, household wealth in New Zealand. 10%, 25% with that's income. With wealth, it is 10% hold 50% of all household wealth. It is not an indicator of poverty and hardship, right? Although it is it's an indicator of poverty and hardship, but it doesn't factor that into its statistical analysis. Poverty and hardship is, of course, referential, but it's not just relative. In other words, we're not talking about abject poverty. We're not talking about, African levels of poverty in New Zealand. That's not how poverty or hardship is defined in New Zealand. In New Zealand, poverty and hardship is defined as excluding people from the minimum accepted way of life in one's own society. So that might be through a lack of resources. This bites hard, in particular in relation to children. Let me give you some figures about children. Māori and Pacifica children make up 34% of all children in New Zealand. Māori and Pacifica make up 34% of all children in New Zealand. They make up 50% of all poor children in New Zealand. We have 3% of the plus 65s are in hardship, and that puts us very near the top of the EU median. So and their rankings, 3% of the 65 and over, it is 18% of children. So if you are a child under 5 years old in New Zealand, there's 18% of New Zealand children, and that's come down from about 21, 22% from the last time they did this report, are in poverty, face poverty and hardship. Over 65s, it's only 3%. So I'm not here to say that the political argument and the political parties are now going to be arguing this ad nauseum between now and September as to whether inequality is increasing or not. And there's different ways you can spin those statistics. The short answer is we have inequality in New Zealand. That has been recognised, and it's consistently been recognised for a number of years. That, I suggest, is one driver as to why I say we might have an opportunity to rethink how we deliver justice, because particularly in the context of access to justice, it hits those people at the lower socioeconomic quartiles harder than others. We live in a multicultural New Zealand that's built upon a bicultural foundation. Right, so that's another driver. We've just actually had a large constitutional review run for the last 3 or 4 years, and it's been co-chaired by Emeritus Professor John Burrows from Canterbury University Law School, and also Sir Tipene O'Regan, who was the Academic Vice-Chancellor of Māori at Canterbury. They were the co-chairs of it. They released their report in November of 2013. It makes really interesting reading. They got in excess of 5,000 submissions from members of the public and community groups as to what the constitutional structure of New Zealand ought to be. So the reason why I've got it there is that we are actually going through as a nation a bit of introspective navel gazing as to what our constitutional structures are going to look like. And as part of that, and pivotal within that, is our system of justice, whether it be criminal, civil, or the broad dispute resolution sector. So we're going through that. We're looking at what it means to actually be a New Zealander in New Zealand, vis-a-vis Māori, vis-a-vis white European, vis-a-vis the other cultures that are flooding into New Zealand. That's only going to increase. I saw some figures the other day that said by 2020 we need 2050 we need 20 planet Earths to be able to support the population. It's only going to get, there's only going to be more of us, all right? So our ability to be able to remain in reality in Ireland is going to be more limited. So we've got to look at these things. Just in the last few days, in fact the last week, of course, we've had the Māori King's son come up to court on burglary and alcohol driving charges, among others, and was discharged without conviction, much to a hue and cry of many sectors within New Zealand. Well, what does that mean? What's that about? Does that actually conform with our notion of justice? Is this actually some cultural sensitivities gone mad, or is this something that actually we can take an essence of that out, whether you agree with that or not, but is there a one-size-fits-all with our justice system? So it's cases like that that I suggest are probably increasingly going to mean that we're not necessarily just going to have this adopted European, predominantly white male middle-class justice system. It's going to become more nuanced, whether we like it or not, so we might as well actually address that in a more positive way. That cultural relativism is a really interesting point. Countries around the world are really struggling with the notion of cultural relativism, where you've got people coming in that it's all well and good to say, you've come to our country, you sign up to our culture and to our justice system, but the reality over years and with these communities developing, then the system and the culture actually becomes much more nuanced in and of itself. Te Tiriti o Waitangi, the Treaty of Waitangi, what's the position of that? It was interesting that the Constitutional Review suggested that if we were going to go down the path of a written constitution, that the Treaty of Waitangi ought not to be part of the written constitution, notwithstanding that it's a foundational document of New Zealand. And what does a post-Waitangi Tribunal grievance settlement process New Zealand look like? What does it look like? And we move from the 70s, 80s, 90s into the 2000s of the grievance process having now being in its last years. What are we going to be as a society and a culture after that? Because the reality is that Māori and Pacifica are far too overrepresented in our criminal justice system and are probably at the sharp end of those who have difficulties accessing justice. And that's a problem for all of us. That's not necessarily, that's something we all should be very concerned about. And any developments in the areas ought to take into consideration a bicultural foundation of New Zealand. A growing perception, and this is just anecdotal and I could be completely wrong on this, but a growing perception of one law for the rich and one law for the poor. And I suppose that goes hand in hand with the notion of inequality. Whether it's increasing or not, or whether just the gap is becoming larger. I perceive, and I do a lot of travelling around speaking to a lot of people, but from my perspective, and it is only a subjective personal experience, I feel as if there is a great deal of cynicism about our justice system, criminal justice system, but also the civil justice system, particularly in Christchurch, where people are feeling as if there is no hope, there is no ability to get my difficulties with EQC, for example, resolved, and they're disengaging in a sense with the system through necessity, and therefore the cynicism rise, a breakdown of cohesion and trust within the society, and we all pay the price of that. Final point there why I say I think we have a chance here to rethink how we deliver justice is the Canterbury Quakes, and that goes to what I was saying before about we've reconstituted what it means to be a community. I think our greatest danger is that we just fall back into where the streets are wide and the minds are narrow, although I loved my old Christchurch. We actually, I think, have come out of this stronger in many respects. I know that there are a great many of us are still hanging on by our fingernails, but for those people who can stand up and show enthusiasm and energy and vitality and support the community, I think they're needed more than ever. And so with a redesign, even a physical redesign of our central business district and our community, there comes an opportunity to rethink about how we actually deliver justice in the organisations that revolve around a courthouse. Because it's not all just about a courthouse, and we know we've got the Justice Hub. You ask any of the judges, they probably, many of them may raise an eyebrow and express some mild, that's probably even putting it too much, but some hesitancy about a Justice Hub, simply because of the notion of a separation of powers, and that being co-located effectively next to the police station might give the impression for those people who have the misfortune of coming into the front doors of the courthouse, that they're all in cahoots with one another. And the judges would say it's not merely academic. This is important actually for how we communicate and how we engage with our community. We all know that our built environment plays a significant contributing factor about how we actually interact with one another. So the Canterbury Quakes, I think, has given us an opportunity to relook at things. The themes of this talk, I say that accessible justice for all is possible. Right? Accessible justice for all is possible. Access to justice is a right It's not a privilege. It's a fundamental right. It's not a privilege. I say that the effectiveness of our communities relies on timely, affordable and effective justice. Right? So you need to be able to provide justice, otherwise it eats away at the fabric of who we are as a community, those things that bind us together. We're all going to have disputes. That's human nature. Conflict is what we're about, but we have to have the mechanisms in which we can have that timely and affordable access to resolving those disputes. Otherwise, we're not going to develop and prosper as a community. If there is one thing that stops direct foreign investment in third world developing countries, it's a lack of a comprehensive and workable justice system. And therefore law and order and everything else that goes with that, the lack of social cohesion, creates an unstable environment significant enough to stop direct foreign investment. But finally, the theme is that it's not, I don't believe it's entirely on the shoulders of the state to provide or to cure everything to do with access to justice. And you'll see why I say that. We're all part of this community. We all need to stand up and be counted for it. We took on and took under our wing Phillipstown School. We all know Phillipstown School, I'm sure, Decile 1 school, a desperately impoverished part of Christchurch. The average family income is $20,000. 1 in 3 parents do not own a car. Lots of kids turn up without shoes and without food in their stomach. And we can all just say, well, they should just be punished, those parents. Well, poverty, from my experience with Phillipstown School, is not merely a socio-economic condition, it is actually a way of life. And so when I issued a press release, and it shouldn't be like this, but this is the way the world goes, the media come flooding, right? Newspaper, radio, TV, immediately. Poor people go and issue a press release, nobody's really interested. Dean of Law goes and issues one, they're all there. And the first question was, why is the Dean of Law interested in this? And I'd actually get really annoyed with them and say, why isn't everybody? I take offence to your question. Why isn't everybody? Because it's about our community. I might live over in the western suburbs. I live in St Albans, but I don't have no connection with Phillipstown. But that doesn't mean that it's not part of my community. We all need to start standing up and being counted out for our community. The government is not going to come in on its white horse and fix all our problems. You know, to a large extent, we can still agitate that they ought to do more, and they most certainly should do more, and they should be working with our council in a much more proactive and healthy way, and they should be standing up, both central government and local government, but we also need to be able to take on the resurrection of our community on our shoulders. So why I say there is, hopefully it'll become manifest why I say it's not entirely about the state. Key concepts. Let's have a look at some key concepts. What on earth am I talking about when I say access to justice, or the justice gap that it is often referred to? A definition. I have to go to Australia to find a definition. There is a paucity of research that has been done in New Zealand that has brought the notions of access to justice together. There are specific, I've got a report here actually that's just been completed by Community Law Christchurch, improving beneficiaries' access to justice, experience with their welfare law needs and how community law centres can respond. So there's a really good report. I've got it in draft, but I think it's going to be released very soon. If not, has already been released. I'm sure you'll be able to find it on their website if you'd like to have a look at that. And we also have, the Human Rights Commission. I've got another report here I'll refer to in a moment. We've got different reports that sort of border on, like concentric overlapping circles, border on this notion of access to justice, but actually hardcore research on what the problem is. There is a paucity of that in New Zealand. But this, I quite like this definition. It says legal problems that remain unresolved or are resolved unsatisfactorily, regardless of whether any action is taken and regardless of whether there is any involvement of lawyers or the justice system. Access to justice, I like that. I like that definition. We'll come back to it in a moment. Other key concepts. What are we talking about when you always hear the rule of law and adversarial system, inquisitorial, legal aid and the profession? Well, the rule of law, as we know, is equality under the law, one law for all, and no one is above the law, including government. So there is no, I'm sure that many a time governments in democratic countries wished they were in government and the totalitarian dictators, because it's quite convenient at times when you want to just move cities or do things. You don't need to engage with the people. You don't need to actually communicate with the public. You just click a finger and you make it happen. We thankfully don't live in an environment such as that. We live in an environment that's governed by the rule of law. Even our leaders are subject to the law. Some of those concerns I had about access to justice that I mentioned earlier eat away and undermine the notion of the rule of law, but that's a concept that you'll hear spoken about in the broader conversation about this, and I'll mention it a few times as well. Adversarial system. We have an adversarial system. The common law system is adversarial. That is about conflict. It's about opposition. It's based on we use juries. We have an impartial court. That's not to say that inquisitorial countries don't have an impartial court, but we have a hands-off judge and a court process that is hands-off and allows the parties to be able to manoeuvre, and effectively the judge is in a sense a referee, and that is typified by having extremely complex rules of evidence. Extremely complex rules of evidence that regulate and dictate what is admissible, what is to be excluded, what can be used with it. Why can't you have previous convictions of a known felon, I'm going to use the United States terminology, before a jury right from the get-go? Why can't you have that? It's always something that is cited to me as an evidence scholar as why the New Zealand criminal justice system is going to hell in a handbasket. My mother always has me on about that. I just say, respectively, I don't know, Mum. I think it is terrible. Yes, I don't be a disrespectful son and go, well, Mother, it's because of this. But anyway, you have extremely complex rules of evidence. But it's not true to say that the adversarial system pervades everything. Actually, we have a huge amount of evidence and foray into the inquisitorial world. Disputes tribunal is, I would say, hugely successful model, massively successful model that by and large adopts a more of an inquisitorial model than necessarily an adversarial model, and quite rightly so. Its jurisdiction has now been increased up to $15,000 by agreement to $20,000. There are a few exclusions, but by and large, if you have a problem that falls under the $15,000 limit, or if by agreement with the other party $20,000, then you can go with no lawyers involved. You might get some legal advice beforehand, but no lawyers involved, and you can rock up to the court and have a disputes tribunal referee go through your case, asking the questions, not lawyers or the count or either side asking the questions, but the referees in control. We have more of an inquisitorial style system, say in the family court. It's not inquisitorial, but a more of an inquisitorial style system. We have the most advanced youth justice juvenile system probably in the world. As far as trying to make sure that youth, wherever possible, are not actually dealt with under the criminal justice model, but more of a welfare model. So there are different ways. There's a lot of discussion about how sexual offending and the trials and the way in which we deal with complainants of sexual offending are dealt with, and that looks like it's moving more towards an inquisitorial style of things. Perhaps even the elimination of juries and having professional judges who are specifically trained in order to be able to deal with sexual complaints and sexual violence and crimes associated with sexual violence. So that's much more of an inquisitorial style system. Moving on to the inquisitorial style system, there predominantly the main feature that we would pick out from an adversarial system is that the judges are much more hands-on. Judges are often appointed as part of a criminal prosecution. Let's take that for an example. They are appointed to actually oversee the investigation themselves. They are not the investigators. It's not to say that they are the people who are bringing the person's bringing the charge and hearing the charge and determining the charge, but they have much more of a hands-on role with the prosecution. A lot of people come and see me and say all our problems of access to justice will be solved if we had an inquisitorial style of courts and processes. That's wrong. They have their own problems as well. Predominantly they're in civil or administrative laws, continental Europe, for example, systems, but that's not exclusive. The two are not necessarily synonymous with one another. But there are things that we can borrow from either side. Legal aid. We have a legal aid system. It's by and large not free money. Mostly it's a charge against your property often, so you have to pay it back, and most often it's in the context of a loan. So it's not always the case. Sometimes it is, but it's not always the case that when you're about to throw your cup of tea or what have you, or your dinner at the TV where you see these directors of failed finance companies and they're all on legal aid and they've all got QCs and what have you, that they're not actually somehow paying for it, although they might have been cunning and have all their money in family trusts and tax avoidance in order to ensure that they have no personal assets that accrue against them. That does sometimes defeat the purpose of the legal aid system. And the profession, the legal profession. What is a profession? Highly skilled, specific training that is usually given to the benefit of the public. Right? This is not just merely a vocation or a job. This is a profession. In a sense, it comes with ethical obligations that are beyond meant to be merely just feathering your own nest or filling your back pocket in a sense. So ideals of service, integrity, honesty, fairness, fiduciary duty, trust, care, duties of care, all of those things are synonymous with a profession. They have a responsibility that goes beyond merely receiving a wage at the end of the week. The extent of the problem, really hard. I told you that there's very little work that's been done on assessing the extent of access to justice problems in New Zealand. Again, I've had to look to Australia, but I think this really encapsulates it quite nicely. Disadvantaged groups not only have non-legal needs by virtue of their socioeconomic status, but also are particularly vulnerable to a wide range of severe legal problems and are more likely to struggle with the problems they face. People with a disability are especially vulnerable to legal problems, although other disadvantaged sections of the community also have heightened vulnerability, including single parents, the unemployed, people living in disadvantaged housing, and Indigenous people. Right? Now, if there's one thing that can be said about the Canterbury Quakes, it was no discerner of socioeconomic status. And so many people, while it might be for the rest of the country, the preponderance of those who are labouring under access to justice problems are poor, Indigenous, disadvantaged because of particular, their socioeconomic, or because they suffer from a disability. In Christchurch, we can't be quite so clear in black and white. The extent of the problem can also be measured by work that has been done around the country. The community law centres, CLCs, do an incredible amount around the country. There's 24 of them around the country. They're all independent from one another and they all struggle from hand to mouth from year on year with their funding. The Christchurch Community Law Centre, or Canterbury Community Law, is the largest community law centre in the country by far. It employs almost 40 people. It services approximately just under 20,000 inquiries a year. I have about 100 to 150 students who volunteer there every year. They now do that for credit. They're not doing that just to make them feel good or for the fun of it. They're doing it for credit. And they have a 40-hour-a-week manned by students 0800 advice phone service as well. They get about 7,000 to 8,000 inquiries through that phone service. They do a tremendous amount of work. So if you want to get a handle, if we want to get a handle on what access to justice problem is in New Zealand, we don't have to go far. We can talk to the people who are right on the front line. And the work of the Community Law Centre is just increasing. They're being inundated. Canterbury Quakes have spoken about. The last one there, rising problems in the family court jurisdiction. Talk to the community law centres and what do they say one of the most significant problems is? People walking through the door not being able to get legal assistance in the family court jurisdiction. Of all the jurisdictions, there are probably family law and youth justice that are the two most proactive sectors of our justice system that actually are not merely the ambulance at the bottom of the cliff but can provide some hands-on skills and ability, mentoring in a sense, mediation to actually work through before things really blow up. And what's happened? It's being strangled through changes to legal aid and what's called the de-lawyering, which we'll get onto in a moment. So we've got a massive problem. You try and find a lawyer in Christchurch who does family law on legal aid, and they're few and far between. They've been culled out in the last 18 months to the last 2 years. And if you cannot find a lawyer to be able to help you navigate through the complexities of marital and relationship disputes, there's no more emotive and volatile circumstance for somebody who doesn't have access to justice to be in. What's some of the drivers? Why do we have this problem? I love The Castle. Who knows The Castle? If you haven't seen that movie, you've got to see it. It's absolute cracker. And within it, there's a great line. There's a couple of there's millions of great lines. There's one where Dale Kerrigan, who's having his house taken away from him from compulsory acquisition, goes to see a lawyer, and she's like, yes, well, I understand, Mr. Kerrigan, it's, your house, and, I don't write the rules, and he just leans over the table. He's quite a simple man, and he says, just stop pretending you're my friend, which I just think is great. Just cuts through it. And she goes, right, fine. And another one where his son goes, who are QCs, Dad, or what's a QC? And he answers, they're lawyers rich people use. If you ever have to pay the bill of a QC, then you understand what that means. But between probably $500 to $1,500 an hour. I would hate to see what the legal bill is for the South Canterbury Finance case at the moment. That was meant to be 16 weeks. I think is probably not going to be much shy of 6 months. There are 3 QCs plus all of their co-counsel as well, and people are paying off their mortgages on the back of that case. So undoubtedly, there is a perception that one of the drivers of access to justice is lawyers are too expensive. Right. I think most of us, there's probably a whole raft of lawyers here, they'll be going, no, not at all. And partially I actually agree with you. The Chief Justice, Dame Sian Elias, came and spoke last year. We've got the Supreme Court lecture series here at the Canterbury Law School, and the Supreme Court judges come. You're very welcome. Give us an email. We'll put you on the email list. And if you want to come along and hear some Supreme Court justices of the New Zealand Supreme Court speak, then we've got another one coming up on the 7th of Dame Susan Glazebrook's coming to speak on the 7th of August. But email us and we'll make sure we get on the invite list. But last year, the Chief Justice came and spoke. And one of the first sentences out of her mouth was, access to justice, one of the main drivers, is the unreasonable income expectations of lawyers. And I was just like sinking down on my seat thinking, I've just invited all of the local profession. But there's a point. Of course there's a point. It's being recorded. I should be careful what I say. It's a little rich coming from the Chief Justice, considering A, she's the Chief Justice, and considering who her husband is. While she was down to give a talk because she's got her 1,000-acre farm or whatever it is up in the hills. But a lot of people have done very, very well, and it's a bit rich for them to then say the income expectation of the current profession is a bit high. But she makes a point. She makes a valid point. And in many circumstances it is. At least the perception is. Let me give you some really interesting figures of a report that's actually just come out. First of all, there's been a Beaton Research and Consulting, is actually from Australia, has looked at the legal services provided at what they refer to as the big end of the town, which I find mildly offensive in and of itself, actually. But anyway, they point out that corporate commercial firms in Australia, and they have a lot to do with New Zealand, although it's not been specifically targeted, they believe the same as New Zealand, there is a consistently falling fee level for the past 5 years. So much so that the author of Mr. Beaton, the author of this particular research, has said that law firms now have to radically restructure how they do business, otherwise they will go out of business. And that's, back office, all the things that everybody else has all gone through, which is, going to external agencies, perhaps for your administration, for example. But let me give you some figures that come out of 2012 New Zealand Law Society on salaries. For a first year lawyer working in a firm, and there's a great many lawyers who don't work in firms, but working in a firm, the range, 80% of the range, because if you took everybody, there's those people who are working effectively for free and those people who are working big corporate American firms overseas or what have you that are earning £120,000 a year but never leave work. I always laugh when the students come and say, "Oh, and they do my laundry," and I go, "Yeah, that's so you don't leave your desk." But they don't quite see that. They don't see that. Yeah, they bring meals to my desk. Yes, because it's a 6-minute billable unit if you leave your desk. But anyway, they have a role to play. But the range is between, for first year, 35 to 55,000. Right, 80% of those who are in the first year in a firm out of law school in New Zealand, 35 to 55. The mean is 45. Now, here is how it goes up. So after 3 years, it's 54, 4 years, 63, 5 years, 71, 6 years, 75, 7, this is the mean, 7 years, 83, 8 years, 88.5, and 9 years, $90,000 a year. Those are the mean. The range for 10 years or more experience ranges from $30,000 a year to $300,000 a year, and the mean is $108,000 a year. 80% of equity partners earn between $90,000 and $400,000. The range is actually from $40,000 to $2 million. So that's the 80% of equity partners and firms earn between $90,000 and $400,000, and the mean is $244,000. So they're effectively at director level. But I think the moral from that story, and that's from firms where they're actually better paid than probably those who have gone out into other areas. The moral of that story is actually a lawyer to meet almost every budget. And it's not necessarily a case that if you don't have the money, you get the worst lawyer. All right? Save for the fact that QCs, that nobody could probably afford the fees of a QC unless they did it pro bono. The reality is I think that legal services in New Zealand is by and large covers the whole gambit. So there is a lawyer to meet your budget. Nobody wants to pay a lawyer though, and you sort of do it begrudgingly because you don't really know what you get. You can't help but think you're being shafted because you just don't, many people don't understand the complexities of the justice system, and it is complex. It doesn't necessarily, not necessarily the case that it should be that complex, but they begrudge it. So in a sense, I think much of the angst against lawyers is driven on the basis, A, of a perception that they're all at the $2 million end, and B, is that we just begrudgingly don't want to pay them because we don't want to be in this dispute in the first place. And I'm a good, fine, upstanding citizen, and I'm honest, so I'll just rock up to the court and say, "Judge, this guy's an idiot, and he's wrong." But unfortunately, you need somebody to navigate you through the system. Having said that, a problem of access to justice? Absolutely. Whether you're the Chief Justice and you say it's the unreasonable income expectations of the profession, or whether you just merely say it's a perceived lack of value from the legal profession. Either way, it's a problem. Legal aid, massive, massive problem. It's been revamped in the last few years. 2009, Dame Margaret Baisley issued her report on the back of what she said were car boot lawyers working out of South Auckland, and I'm sure that undoubtedly there were a number of those, and she was saying that we're rorting the system, and therefore that was one of the main justifications and pillars for a completely restructuring the legal aid system in a way that has led to what I suggest to you is many lawyers just saying, "I'm not doing legal aid work anymore because it's just not worth it." And if you just look at the hourly rate, that's only a quarter of the story. It is all the work that you need to actually submit the bill or the expectation of how many hours you're going to do, only to get it back with red lines through it saying, "We're not going to pay for this, we're not going to pay for this, we're not going to pay for this." So legal aid is meant to, and it is meant to provide or alleviate access to justice, and I'm saying that it could do better. I'm not saying it's not, but I'm saying it could do better. Inaccessibility of the courts, boy, the hurdles you've got to get before a judge these days. Many of them, the flip side, that's a good thing. It's a good thing, because it forces you to actually look at the position that you're in, forces you to mediate. But actually, a lot of people want their day in court, and if you actually want your day in court, it's really hard to get your day in court. Costs orders, I mentioned those at the start of the presentation. Possible solutions. Well, research. You've got to have some research. People aren't doing enough research on access to justice and really understanding. Even I don't really understand exactly what the main drivers are. We have reports like this from the Community Law Centre about, in particular, one aspect of their clientele were beneficiaries. They're not a social welfare service, the Community Law Centre. They're doing high-end, hard-edge law and all sorts of different things. But one large sector of their clientele is beneficiaries, and they've done a report in relation to their access to justice. And we also got the Human Rights Commission here, a big report just released, monitoring human rights in the Canterbury earthquake recovery. It's gone from a destruction of buildings and a rebuilding to actually rebuilding people. It's about people, and that's what this actually says. The processes are not in place in EQC as a basket case, and things are really, people are just being treated atrociously. Now the Human Rights Commissioner and the Ombudsman are getting involved, so that makes really interesting reading. We've got health being reconstituted in Christchurch around the notion of the home. So we need research about how this all actually fits into access to justice. We understand much more clearly about access to health facilities, but access to justice is something that is largely underrepresented in the research. The law profession, yeah, they probably do have to do more. They are a profession. I didn't put lawyers there, I put the profession. They need to do more. Don't get me wrong though, they do a huge amount of pro bono as a sector, massive amount of pro bono. They're acutely aware of the problem of access to justice, and they're doing a tremendous amount. I wouldn't be able to run the innovations that we're running in the law school if it weren't for a practice, particularly a local practice, that's committed to pro bono work, and I really take my hat off to them. The Law Centre, notwithstanding it's got 40 odd staff, wouldn't be able to do its work for 20 odd thousand inquiries a year if it wasn't for the absolute generosity of the profession. But they probably do need to do more. The Chief Justice certainly thinks they need to do more in relation to their income. Public defenders, we now have a public defender in Christchurch in relation to criminal law. It was trialled only less than 5 years ago up in Auckland, and is now being rolled out. And it would be good to see that being rolled out into places that are not merely the main centres, and I think that's working well. And it augments, in the context of the criminal jurisdiction, the legal aid provisions. Adversarial versus inquisitorial. I think we can do much more in the inquisitorial area. Why don't we set up, rather than sending people to EQC through the district court, let alone the High Court? There is some suggestion the District Court might not have jurisdiction for a lot of the High Court, for a lot of the EQC issues that are coming up. But for all those people who are under $100,000 or a $50,000 dispute with EQC, it's not worth even going to the District Court. Absolutely not worth your while going to the District Court, let alone the High Court, and paying the fees and being subject to possible cost orders in the High Court. So why don't we have... One of my colleagues here is a disputes tribunal referee, so she had to block her ears here for a moment. Why don't we extend the jurisdiction of the disputes tribunal to deal with EQC issues up to $50,000? Why don't we do that? Why don't we have a more inquisitorial process by which we don't rely on people having to go and see a lawyer, find a lawyer, pay the fees, or when they just think they've got some sort of problem that they're being shafted, unaware that actually they're in the same boat as many others, and yes they are, and that there is actually possibly some resolution that they could pursue. Court processes. The court processes, I think, could be streamlined. We have talked a lot about, the ways in which we, as in the justice sector, the ways in which cases are actually handled through the courts, and I think many of those innovations are really good. Judges are appointed to civil cases, and they monitor the progression of those civil cases from a procedural point of view through to the end. But it does raise an element of complexity that is very difficult. It also raises the issue of lawyers then having to do all their work at the start, which means that you've got to pay more money at the start. You know, the pleadings, you talk to any district court judge and they say, oh, the pleadings in civil cases, they used to just be bullet points about what the case is about. Now they're novels. We need to get back to what they're bullet points. And I always say to them, look, judge, if you're going to make it so difficult, not the judge, but if the process is going to make it so difficult to get to the day in court at the end of it, right, and it's almost, you've got to go through so many, if you haven't shown an absolute commitment to mediation by the time you get there, then you're probably going to lose the case, or it's going to be looked at very dimly. If you're going to make it such an impossibility or so difficult to get to actually hearing before a judge, of course you're going to put it all in the pleadings, because it's your only opportunity you're going to get to actually have your full say. So of course it's going to be a novel. You can't have your cake and eat it too. So the processes, the court processes need to be looked at. And here's where I say it's not all about the government. Law schools need to change the way they interact with their students. because those students are the ones are going to be the absolute key in the profession, either as lawyers or if they don't go off and become a lawyer, they might be working within the justice sector more in the round. We need to be able to instill in them really what it does mean to be in a profession and stand up for your community. And actually, here in Christchurch, I'm playing second fiddle to my students because the students are already doing this. They're marching off ahead. They're leading the charge. They're not Generation Y. I think Generation Y is the biggest crock of rubbish I've ever heard. These kids are just as ideologically driven as any other group of kids have been in the past, and they are desperate to make a difference and to stand up and be counted and help people, help communities, and be part of something that's bigger than them. So I'm really excited over the next few years. I think we're going to actually find that our demographic of students coming to Canterbury, either at the university, at the law school, Lincoln, CPIT, or just coming into Christchurch, are going to be quite a different dynamic of person as they have found in New Orleans and the universities there. They're now being inundated with people who want to make a difference. They want to stand up, they want to be part, they want the challenge. Yeah, it's a bit gritty, but why would you want to be anywhere else is the short answer. Community law centres, they play a pivotal part. Some people, I think, look at community law centres and say the reason that place exists is a proof that the system is failing. No, I don't necessarily. Perhaps the reason that they are so busy, but I could never imagine a day that we wouldn't have a community law centre because I think that we need different ways of interacting with people that they feel comfortable with. And it's far less intimidating going to a community law centre. Might be in Aranui, where they actually worked and didn't get anybody through the door for the first year because they had to build up the trust and confidence in the community. But they're doing fantastic work and I think they're pivotal. So I think that there are a great many agencies. Look at what's happening out at Ngāhaui Whāra and the marae out in Aranui, the National Marae for Urban Māori, where in the whare there is actually district court sitting. And a rangatahi court is actually about to stand up with youth justice focused around the Māori in Christchurch, but in particular in that community. Fantastic stuff. So I think actually that while the government might actually have to pay for it, they're not necessarily the ones that are going to come up with a resolution. It's our community. We've got to make the difference. We've got to go hand in hand with our government rather than just stand back and say central or local government ought to do it all. A few things we're doing in the law school just to finish up on. Next year, law students, whether they like it or not, from first year on, before they graduate, will have to do 100 hours of community engagement. That's not just any community engagement. It's not necessarily student volunteer army and shoveling silt and stacking bricks. We've moved on from that. It's actually engaging their mind. It's engaging them in ways that I think is pivotal to our community, but also good for the students. I'm not there, I always tell them, I'm not here to turn you into bleeding heart liberals. I'm not there to promote service for the sake of service. I'm here to give you the skills that you need to be able to survive in the world. And you've got your core academic skills, but we need to augment that with actually some practical skills. It's also going to help them in their academic endeavours because it gives them a structure and a framework and motivation and passion in order to be able to put more into their academics. So I think it's a win-win. This 100 hours is and if it works well, we'll increase it. The engineers do about 800 hours of professional engagement over the life of their degree, and if any engineers can do it, boy, lawyers can do it. We need to make the training, as community health is to the training of doctors, community legal services ought to be to the training of lawyers. You'd never go to a doctor who'd only read about illnesses or people in books. Why go to a lawyer or some professional in the legal area who'd only ever read about things in the library? You want people who've got hands-on experience. We're the largest internship program in the country now. I basically say to my students, you're here to change the world. We're not a degree factory. If you think we're a degree factory, then just let's have the talk about how you can go somewhere else, because I don't want you here. Right? I've already wound them up saying it is the only place to be, so it's a bit of smoke and mirrors. It's now being recorded. They're going to realise they're going to see through me. But this is the place to be, but you're going to get your hands dirty. You come to Canterbury, you're going to get a good degree, like you will at all the law schools in New Zealand, fantastic quality, but you're going to get your hands dirty with real people with real problems. So Tainapura, I've got 2 students working on that with the legal team. I'll fly them to London to help argue in November at the Privy Council. Michael October is a case very similar to Tainapura, but in the early stages. EQC Challenge, I've got 50 students working on that, helping Peter Watts at Anthony Harbour with the EQC Challenge. ECAM, we've got students who are going to be working there on their Prosecution Service, DOC, same. Law firms, they get jobs over the summer, they can get credit for that and part of their transcript. We get them to do extra academic work, of course, on top of that. Even had some working at Forest and Bird. EQC, we even had a couple actually who were working in EQC. Forestry prosecutions, you've heard about the forestry prosecutions, about New Zealand's atrocious record of health and safety in the forestry sector. Nigel Hampton QC is taking those on pro bono. He's taken a whole lot of students to help him with that. And they're doing some really good work, important work. They're not just merely just sitting there holding his books and what have you. Community Law Centre, you've heard about our relationship there. The Canterbury Insurance Advice Service, we've got a whole lot of students who are working with them. And we've got New Zealand's only US House of Congress. I organised that a couple of years ago when I was a Fulbright professor at Georgetown. All expenses paid for 2 law students to carry the books of 2 congressmen over summer, which is great. That is an eye-opener for those kids. 28 clinics. We're going to run, in conjunction with the Community Law Centre, 28 clinics in and around Christchurch. We're going to change the world. Right? Because the students are up for changing the world, and it's a university, for heaven's sake. So we've got 28 clinics. It'll be landlord and tenant, all sorts of different things: immigration, refugee, domestic violence, right through to the entrepreneurial advice clinics, small business clinics, and including overseas clinics: East Timor, Vanuatu, ICC, the International Criminal Court in The Hague. Conclusion: gone over time. What do I want to take you to take away from this? Access to justice, it's a right to access justice. It's part of the Bill of Rights Act. It's infused within the Bill of Rights Act. It's infused within our constitutional structures in New Zealand, that we have mechanisms to resolve our disputes with one another. It's not a privilege, it's a right. It is needed to maintain and grow community trust and cohesion. Our communities fall apart when you don't have effective access to justice. As a result of that, I argue it makes good economic sense. Now that's the biggest impediment, I think, to access to justice. It's the government not realising that an adequately funded community law centre and those other agencies are not merely just nice to haves. They are the ones who are giving effect and are allowing and empowering many of our citizens to actually be part of our community. And they are as important as lawyers, as the police, as corrections, as the courts, as judges. They are integral to the system. Take them away, the system falls apart. So they need to be adequately funded. Multiculturalism requires a nuanced approach to justice. That's just the reality of what's going to happen. Government does not necessarily need to provide all the answers, but at least initially it might have to fund a great many of them. But don't underestimate people's goodwill towards their community. They will go so far until they feel as if they're actually being taken advantage of. But that so far, in my experience in Christchurch, I am utterly astounded by how much people will do for their fellow man. And finally, it's for all of us to support our community. So I don't think we're ever going to get on top of access to justice if we merely just say it's the government's problem and it's the government's fault. It's all of our responsibilities. It's our community. We've got to make it work. Thanks very much.